The Fugitive Slave Act of 1850 is part of a larger legislative package known collectively as the Compromise of 1850. The Fugitive Slave Act really deserves specific mention. It was referred to as the Bloodhound Law by its dissenters and detractors, and for good reason. It was so destructive, really, to the overall public and political discourse at the time that it is often attributed as being one of the kind of, not necessarily the causes, but indicator of the looming Civil War. It was also instrumental in kind of a backwards positive fashion because it forced Northerners who were ambivalent on the issue of slavery, they were forced to take a position. So in that respect, through its totalitarian overreach and clear constitutional abuses, the 1850 Fugitive Slave Act did really solidify the anti-slavery sentiments in the North by forcing those who just wanted to claim the Switzerland defense as having to take a side. And it did this, among other ways, by requiring free citizens in free states to assist in the apprehension and subduing of presumed or accused fugitive slaves. As one can logically assume, this created a kidnapping enterprise where Southern bounty hunters would often go into the North, really find any black, usually drug or another way or in some other way mug them and kidnap them, take them to the South, and sell them as slaves. Now, since the colonial era, numerous states had passed various liberty laws, ways to protect not just fugitive slaves, but free blacks. Northern free blacks were always at risk of being kidnapped and abducted by Southern bounty hunters is almost too kind of a term. We'll say slave traffickers, how about? And so many states passed laws that required habeas corpus, trial by jury, the things that you're supposed to have. So it's really just a reiteration of established norms, but making sure that those were applied at the state level to that particular group of targeted individuals. And of course, those laws were natural extensions of natural rights theory, and as such, they applied to blacks as well. All of these laws were effectively nullified by the 1850 Act, and that was one of the most galvanizing and frustrating aspects of the Act. For most of the history of the United States at this time, it was understood that slaves had states had a specific kind of sovereignty, not to be confused with the erroneous states' rights arguments that's presented generally in defense of slavery, and unfortunately has been really kind of demonized because of white supremacists and slaveholders of the Democratic Party throughout history now make the concept of states' rights pejorative. But a brief reading of the Act really highlights how awful it was, especially and just on the inherent level of overreach. So, in summary, it punishes any citizen who refuses to participate in the apprehension of alleged or accused fugitive slaves. Of course, this is a clear violation of the Fourth Amendment, and it further violated the Fifth Amendment because it levied massive penalties against citizens who were not accused of committing a crime, but they were accused of not helping capture slaves. Of course, these alleged fugitives were denied their own due process rights. They weren't given a grand jury or whatnot either. And further, this law actually incentivized both judges and magistrates who were exercising unconstitutional judicial authority to decide against the accused fugitive slave. They were compensated at a higher rate by the federal government for finding guilty determinations for fugitive slave cases. So there was even a monetary incentive to find any black accused of being a slave as being a slave. So Section 5 really kind of expanded this anti-constitutional assault. It empowered federal marshals with the authority to command any and all citizens to function as a posse comitatus in the location and apprehension of alleged slaves. Now, if you refuse to participate, you could be fined under Section 7 of the Act. And the fine at that time was $1,000, which $1,000 today, that's pretty hefty, just for refusing not to, football tackle a fugitive slave. But if you adjust that fine for 2022, that would be a fine of almost $37,500. So crippling, if you will. And Section 6 of this act prohibited the accused fugitive slave from testifying on their own behalf. So just egregious constitutional abuses afoot here. Now, and this obviously the act violated Article 1, Section 3 of the Constitution also because it allowed magistrates to exercise judiciary powers. And judiciary powers were specifically enumerated in the Constitution, again in Article 1, Section 3. So this was an illegal delegation of power down to magistrates who were not even a part of the court system, and they certainly had not been ordained and established by Congress, which is required in the Constitution. So you had a series of not judges acting as judges and then getting compensated at a higher rate for finding guilty verdicts. So no problem there, right? And what's truly interesting about this act, though, is that the South did not praise it. Generally, they were discontent because they felt like there should be more enforcement mechanisms. So they actually compared the subsequent additional state laws meant to enforce habeas corpus, right to trial by jury, trying to combat the 1850 slave law, which had really was the story of slave legislation throughout the history of the United States at this point, was southern slave states trying to enact laws to protect it, northern states trying to just protect natural rights and uphold the Constitution through their legal system. And the 1850 Act is a rare instance where the law would seemingly be beneficial to the southern slave states, but it simply wasn't enough for them. So in the Charleston Mercury, which was the most widely circulated southern newspaper, and of course it was owned and published by a Democrat fire eater, it decried the terrible insistence on habeas corpus as it sanctions the violation of all faith with the slaveholder, the robbing of his property, and the taking of his life. So it should be kept in mind, of course, that simply insisting on habeas corpus, it wasn't the same as just kind of unilaterally declaring a fugitive slave free from the act. He would, if he or she was in fact a fugitive slave, that they would be returned to the South and whatever supposed owner they had. But simply adding that step is conflated as murdering slaveholders. So you see this kind of continuation, this really, really escalated incendiary rhetoric by the Democratic Party, or even a law that was really productive to their use. Any perceived lapse in that law, and in this case, a state law that wouldn't even free the slave if he or she was in fact a slave, they compare that to murder. So they're telling their southern population, hey, northern states, by even slightly observing what's been an understood right under English common law for hundreds of years, they're trying to kill you. They're trying to rob you of your property. And of course, that's always an interesting point that they make because over 3/4 of white Southerners owned no slaves anyhow. Now, there was if one can find the silver lining, other than galvanizing the North against slavery, by forcing their participation and threatening federal punishment for not participating. The Underground Railroad saw a surge in activity. It had existed prior to the 1850 Fugitive Slave Law, but just like the North more generally became far more politically active in the slave issue at this time, after the law was passed, the Underground Railroad also expanded, grew, organized, and really began to build that reputation that has forever and rightfully solidified it in favorable position in American history. It also inspired the creation of numerous self-defense groups. I love these especially. A big proponent, the natural right to self-defense, Second Amendment, all these wonderful things, which I would encourage you to listen to the weekend episode number 2, which I explore those subjects specifically to great extent. But pursuant to that understanding, groups of both white and blacks would come together, train, acquire weapons, and develop strategies to defend themselves, because this law was abused routinely to abduct and kidnap free blacks from the North and resell them in the South as slaves. Many respects, that was a much easier market than trying to find a particular slave. Let's say in New York City, if a slave escapes there, it's going to be very difficult to find, but not so difficult to find any black, drug them, and then sell them in a Louisiana slave market. So you had numerous self-defense groups pop up during this time period, and they were actually very effective at defending not just fugitive slaves, but legitimate free blacks in the North. Of course, the North had gotten rid of slavery as early as 1804, with really largely before even the 1800s, but going by technicalities here. And, this is 1850, so the Southern Democratic states, they are just full bore into the slave institution at this point. So one of the best responses to this act was, of course, by Frederick Douglass, amazing human being, amazing man. One of the most formative books I've read in my life was his autobiography. And unfortunately, the speech that he gave, largely in response to this act, is very much selectively quoted as a larger condemnation of America and the founding, which is very much untrue. Douglass, being extraordinarily well-versed in American history, and the founding era specifically, he uses the present circumstances as a foil to the founding era, not to malign the founding era, but to say, look at how far we have fallen from those guiding principles that founded the nation, and from those fathers of the nation that put into place these systems that were meant to destroy slavery, and look how that system has been perverted. And again, it's important to recognize that this was a circumstance that really only persisted in southern states at this time. The North, for much to its credit, the Republican Party hadn't yet formed, but the northern elements were already well on the way, and the Whigs, free soilers and whatnot. But they were passing laws to try to protect blacks. So, in the speeches specific to the 1850 law, the Venerable Frederick Douglass, he writes, and I quote, "The fugitive slave law makes mercy to them a crime," them being slaves, of course, "and bribes the judge who tries them. An American judge gets $10 for every victim he consigns to slavery, and $5 when he fails to do so. The oath of any two villains is sufficient, under this hell-black enactment, to send the most pious and exemplary black man into the remorseless jaws of slavery. His own testimony is nothing. He can bring no witnesses for himself. The minister of American justice is bound by the law to hear but one side. and that side is the side of the oppressor. Let this damning fact be perpetually told. Let it be thundered around the world that in tyrant-killing, king-hating people, loving democratic Christian America, the seats of justice are filled with judges who hold their offices under an open and palpable bribes and are bound in deciding in the case of a man's liberty to hear only his accusers. And Douglass is completely justified in his observations and his condemnation here. And the reason that justification exists is specifically because of how far removed this reality was from the founding doctrine, from the words and wishes and the systems put into place by the founding fathers, especially in the terms of justice. And see, he lines here too, that all of these things have been done at the federal levels. These judges are only allowed to hear part of the testimony. So it's really not even the courts themselves, but what the courts have been perverted into by congressional legislation. Something that would, this is a reality that would be further compounded in the Dred Scott decision through an activist Supreme Court and the collusion with Democrat leaders in the party at the time. So he then notes that the current circumstances were in rejection of the founding. So let's examine that part that is most often excluded from the conversation. Douglass, he speaks, or / quote, writes, "Fellow citizens, I am not wanting in respect for the fathers of this republic. The signers of the Declaration of Independence were brave men. They were great men, too great enough to give fame to a great age. It does not often happen to a nation to raise at one time such a number of truly great men. The point from which I am compelled to view them is not, certainly, the most favorable, and yet I cannot contemplate their great deeds with less than admiration. They were statesmen, patriots, and heroes, and for the good they did and the principles they contended for, I will unite with you to honor their memory. They loved their country better than their own private interests, and though this is not the highest form of human excellence, all will concede that it is a rare virtue, and that when it exhibited, it ought to command respect. He who will intelligently lay down his life for his country is a man whom it is not in human nature to despise. Your fathers staked their lives, their fortunes, and their sacred honor on the cause of their country, and their admiration of liberty, they lost sight of all other interests. They were peacemen, but they preferred revolution to peaceful submission to bondage. They were quiet men, but they did not shrink from agitating against oppression. They showed forbearance, but that they knew its limits. They believed in order, but not in the order of tyranny. With them, nothing was settled that was not right. With them, justice, liberty, and humanity were final, not slavery and oppression. You may well cherish the memory of such men. They were great in their day and generation. Their solid manhood stands out the more as we contrast it with these degenerate times." Now, it bears understanding that early in his life as a free man, Douglass was exposed to what was at the time considered radical abolitionism, which generally maligned the Constitution and founders as pro-slavery racists, which is kind of an irony since that's kind of the current revisionist standpoint on things. Radical abolitionists during the founding era and even to an extent in the antebellum era are being plagiarized by modern historical revisionists. But as Douglass talks about oftentimes in his many publications, speeches, and of course autobiographies, was that as he came to educate himself and understand the circumstances and really read their words, it radically transformed his understanding of the founding, the Constitution, and such things. So we see here that process already almost completed. He still harbors a bit of kind of an angst against the founders, and one really can't judge the man for that. But he nonetheless has come to acknowledge that not only were they not pro-slavery or racist, but they put into place institutions meant to destroy that thing, and that they, compared to the present day, just demonstrate how far the public and the government had fallen. Now, often this speech is construed as being a kind of as Douglass trying to communicate some kind of hypocrisy, but it's generally just that traditional means where they'll pick a couple sentences and then use that and say, "Hey, look, here's 2 sentences out of a 20-page speech, and we've determined what he means from these 2 sentences." So comparatively, no. But Douglass does offer a very legitimate and fully justified criticism, and that just reflects the abject tyranny of the 1850 Fugitive Slave Law. And what it did also for a lot of ambivalent Northerners is it shattered their hopes that simply living in a free state insulated you from slavery. And this would become even more pertinent with subsequent conspiracies and strategies implemented by Democratic administrations to expand the power of the slave states. You have the and prior as well. You have the Mexican-American War, for example, the annexation of Texas, the controversy also of the Ostend Manifesto, of course, and the subterfuge in Cuba, Democrats upholding pro-slavery regimes in Nicaragua, wanting to invade the Yucatan, and then the Kansas-Nebraska Act effectively creating a miniature civil war between pro-slavery and free state forces. So their concerns were justified, and really this act played a critical role in changing the public perception on this, a perception that would be addressed by Abraham Lincoln extensively against Stephen Douglas, and the infamous and terrible Dred Scott decision that should remind everyone of the present day and forever that the Supreme Court is not an omnipotent 9-member bench of demigods, but flawed, biased human beings culpable to sin and corruption. But regardless, one of the leading concerns with that decision was that now, having effectively opened the floodgates of slavery in the territories, they were one lawsuit away and one Supreme Court decision away from forcing slavery into states that had already declared themselves to be free. So this act, generally not too far addressed, but it is instrumental in understanding this just volatile temperature and environment leading up to the Civil War. And this is all the way into 1850, so we've still got 11 years left before the states secede. And a lot of things happen in that time period, several of which we've already discussed. So if you've learned anything from this episode today, or you like what you hear, give me a 5-star review, follow it, share, tell your friends, and please feel free to visit 1787project.com to learn about a 6-volume series that corrects the historical record on slavery in America.